All right, let's begin our discussion of business organization law by discussing some terms and concepts that are important. First, let's discuss what business organizations are. Sometimes they're also called business entities. So we have four basic business organizations. We have the corporation, the limited liability company, we have partnerships, and we have sole proprietorships. We might not consider sole proprietorships to be business organizations, and as we go through the terms and concepts, you'll see why. So in this course, we're going to focus on corporations, limited liability companies, and partnerships. These are the business organizations or business entities that we're going to explore. Now, there are some other business organizations and entities, but if you understand corporations, limited liability companies, and partnerships, you'll be able to understand the other business entities that may be out there. For each of these business organizations, the issues are the same, right? The issues that you run into in corporations do not differ from that of limited liability companies or partnerships, but the law may approach these issues differently depending on what business organization you have. Let's explore that concept a little bit more in depth. Business organization law deals with the relationships among the people involved with these business organizations. And who is involved with these business organizations? Well, we have owners and we have management. Now, sometimes the owners might be the management, and therefore we won't have that relationship problem, but we'll still have issues with respect to the relationship between the owners. All right, let's discuss a very important concept in business organization law called limited liability. Now, limited liability means that the owners of the business are not personally liable for the debts of the business. Owner liability is limited to her investment. So we call it limited liability. We do not say no liability. Why? Because an owner will still be liable for the debts of the business up to the amount that the owner has invested in the business. Let's look at an illustration. In our illustration, we have a shareholder, and a shareholder is just one of the owners of a corporation. A shareholder invests $100,000 into the corporation. The corporation owes $500,000 to its creditors. The owner is only exposed up to her investment, which is $100,000. She indeed might lose her $100,000, but she will not be personally liable for the debts of the business, which means she will not lose her car, she will not lose her house, her wages are not exposed. All right, so here's the Butler did it, the result. A corporation, the shareholders, the owners of a corporation enjoy limited liability. Similarly, the owners of an LLC, and those are called members. They're not usually called shareholders, they're called members. The owners of a limited liability company enjoy limited liability, hence the name limited liability company. The owners of a partnership, and they're called partners, the partners do not enjoy limited liability. Now, there are a couple of partnerships, a couple of special partnerships where the partners will enjoy some aspects of limited liability, and we'll explore those later in the course. But for now, think of the partnership as a business organization where the owners, the partners, do not enjoy limited liability. A partner will be personally liable for the debts of the partnership business. All right, as we move on, let's talk about two terms that are often used interchangeably, but they really have specific meanings: incorporating and organizing. You incorporate a corporation and you organize an LLC. Sometimes you'll hear someone say that we incorporate an LLC. You don't incorporate an LLC because it's not a corporation. You organize it. And sometimes you'll hear people say, let's organize a corporation. Generally, the proper term is you incorporate a corporation. In any case, incorporation and organization are just formation. So if you want to use the term formation, you can say that too. We form a corporation or we form an LLC. Incorporating and organizing are just the formal formation processes. And the formal formation processes is that you send an application to the Secretary of State, and the application must take a specific form, and you pay a filing fee. And then you have incorporated your corporation or you have organized your LLC. Sole proprietorship formation, there is no sole proprietorship formation. A sole proprietor is just one person doing business, and this person has not formed a corporation or an LLC. When you are one person doing a business without a corporation or without an LLC, you are a sole proprietor. And so we don't really look at sole proprietorships as business organizations, but we'll continue to mention them in passing throughout the course. Partnership formation. Partnership formation is a little bit different. A partnership, you don't need any type of formal filing with the Secretary of State. You form a partnership simply by doing business with someone else. And this is what I mean by doing business with someone else. You and that other person or several other people are co-owners of the business. If you and someone else or several other people are co-owners of a business for profit and you do not incorporate a corporation and you do not organize an LLC, then you are a partnership. So once again, a partnership is just two or more persons carrying on as co-owners of a business for profit, and you don't incorporate a corporation and you don't form an LLC. More on that as the course progresses. All right, let's talk about the importance of the size and scope of business organizations. We're talking generally about small and large business organizations. Now, when people think of small and large business organizations, they sometimes think of economic scope, large assets or small assets, or large revenue or small revenue, and the same with profit. And that's one way of approaching business organizations based on the size of their business operations. But in this class, we're going to look at the size and scope of business organizations through a different lens. We're going to talk about closely held businesses. We're going to talk about public companies or public businesses. Usually we say public companies, or private companies. First, let's just introduce the concept of a closely held business. A closely held business has a relatively few number of owners. So we're talking 3 or 4 owners, maybe 10. What's the number where you go past being a closely held business? I don't really know, but a closely held business has a relatively few number of owners. What's a public company? Well, a public company is a company where the ownership interests are publicly traded, usually on a stock market like the New York Stock Exchange or NASDAQ. So think of public companies that you know about, P&G or GE or Disney, something like that. these are corporations whose ownership interests, in this case the ownership interests are called stock. When it's a corporation, the ownership interests are called stock. The stock is traded on the New York Stock Exchange or on NASDAQ. And when you have a public company whose stock is traded on a public exchange, you are generally going to have a large number of owners, a large number of dispersed owners. And in the case of a corporation, the owners are called stockholders or shareholders. What are private companies? Well, private companies are just companies, business organizations, with a relatively large number of shareholders, but their owner interests are not publicly traded. So you might have a corporation that has 200, 300, 400 owners, 400 stockholders or shareholders, but the ownerships are not publicly traded. So a private company has moved beyond what we would consider to be a closely held business, right? 200, 300 shareholders is no longer a closely held business. But the ownership interests are not publicly traded, so we will refer to this as a private company. Now, closely held businesses are necessarily private companies, but not all private companies are closely held businesses. As we said, you might have a private company, right? A company where the stock, the ownership interests are not publicly traded, but you have a large number of owners, a large number of shareholders, so you will not be considered a closely held business. All right, let's talk about the governing law. There is state law and federal law that govern business organizations. State law governs the formation and the internal governance of the business organization. We're not going to look at the law of every state. We will generally look at Ohio and Kentucky, sometimes New York, sometimes California. We'll definitely look at Delaware because Delaware is a very important state with respect to publicly held companies. But in our course, we're mostly going to focus on the business organization law that we find in model and uniform acts. In law school, you're familiar with using model acts and uniform acts. For the corporation, we're going to look at the revised Model Business Corporation Act. Quite a few jurisdictions have adopted early versions, some version of the Model Business Corporation Act. The Model Business Corporation Act has gone through several revisions. We're going to look at the most recent one, but keep in mind that your state, if it has adopted the revised Model Business Corporation Act, it might be one of the earlier versions. For partnership law, we're going to look at RUPA, the Revised Uniform Partnership Act. Most states have adopted the Revised Uniform Partnership Act. Some states might still have the older version, the Uniform Partnership Act, UPA. We're going to focus on the Revised Uniform Partnership Act. And for limited liability companies, we're going to look at quite a few approaches, but mainly we're going to look at the Revised Uniform Limited Liability Company Act. The problem with the Revised Uniform Limited Liability Company Act is that it is not uniform. It has not been uniformly adopted by the states. And so when you look at the limited liability company law, there are various different approaches. We can't look at all of them. We're going to focus on the Uniform Limited Liability Company Act or the Revised Uniform Limited Liability Company Act. How does federal law govern business organizations? Well, federal law mostly governs securities and stock. Ownership interest in business organizations are generally considered securities. We'll talk about that more later in the course, but for now, think of ownership interests in business organizations such as stock in a corporation as a security. When these securities are publicly traded, federal law will govern many aspects of the security. So for example, when we have public companies and the stock of those public companies are traded on a stock market, these public companies must make certain public disclosures. This is an aspect of federal law, federal securities law. Federal securities law requires these companies to make public disclosures, to give information to investors in the market. And more recently, in the past 15 or 20 years, federal securities law has taken steps to govern the internal governance of business organizations. And when we're talking about internal governance of business organizations, we're talking about the relationship between the owners of the company and the management, or the relationship between the owners themselves. All right, let's talk about the Internal Affairs Doctrine. The Internal Affairs Doctrine is just a choice of law rule that says the internal governance of the business entity is governed by the law of the state of formation. So, for example, imagine you form a corporation. You incorporate your corporation in Delaware, but you have your headquarters and your manufacturing facilities in Ohio. Now, imagine there is some sort of dispute between the shareholders and the management of the company. What law governs this dispute? Is it Delaware law or Ohio law? Well, the Internal Affairs Doctrine says the internal governance issues of a business organization are governed by the state of formation. So in this case, the state of formation is Delaware. The corporation was incorporated in Delaware. All right, so what is internal governance of a business organization? Well, we're talking about the relationship between the owners. If we have a closely held business and we have 4 or 5 owners, then we might have some disputes among the owners. What law governs those disputes? It is the law of incorporation. The law of the jurisdiction of incorporation. We might have disputes between the owners and the management. So for example, imagine we have a large public corporation with hundreds of thousands of shareholders, and the management is running the corporation, and these shareholders are unhappy with the actions of the management. What law governs this dispute? Well, it is the law of the jurisdiction of incorporation. Let's talk about some basic finance concepts. Finance is just how a business organization will raise money to engage in its business or to take on projects. So there are 3 basic sources of financing. There is debt financing, equity financing, and earnings. First, let's talk about debt financing. Debt financing is also called a fixed claim. It is bank lending or trade creditors or debt securities. So imagine a business organization borrows $100,000 from a bank. This is what we call debt financing. It's also what we call a fixed claim. Why do we call it a fixed claim? Well, the business organization is obligated to pay back the $100,000 plus interest. If the business organization does poorly, doesn't make a lot of profits, it is still obligated to pay back the $100,000 plus interest. It's a fixed claim. On the other hand, if the business organization does fantastic in its business and makes a lot of profits, it still only has to pay back $100,000 plus the interest. This is the nature of the fixed claim. Now, as we mentioned briefly just a second ago, there are 3 basic forms of debt financing, you have bank lending, which we're all familiar with, you have trade creditors. So I might sell goods to you on credit. And that, in that case, I am one of your trade creditors. So if a business organization buys goods or services from another party on credit, that other party is now a creditor to the business organization. And that trade creditor has a fixed claim against the business organization. There are also debt securities, and you're probably not quite as familiar with debt securities. You've probably heard of bonds, and that's essentially what debt securities are. We'll discuss those a little bit more later in the course, but essentially a debt security is where a business organization borrows money from a large number of lenders. It's like selling stock, but you're not selling stock, you're selling bonds. So instead of borrowing $300 million from one bank, our business organization issues bonds, and it issues $10 bonds to a large number of lenders. And we'll call these lenders investors. And so we don't have one lender, we don't have one creditor, we have many creditors. And that's the nature of debt securities. Once again, they're often also just referred to as corporate bonds. What's equity financing? Well, equity financing is just selling ownership interests. Or often we say a business organization issues ownership interests. They're also called equity interests. And we'll explain why they're called equity interests in just a little bit. But the equity interests that you are probably most familiar with are stock or shares. If you get stock in a public company, you have equity interest. You have an equity interest in the public company. Stock is the equity interest, the ownership interest in a corporation. A membership interest is the equity interest in an LLC. And a partnership interest is the equity interest in a partnership. Now, why do we call these equity interests? Well, because the equity interest is the residual claim. It is what is left over. Let's look at that in comparison to the fixed claim. Remember, the creditors of the business organization have a fixed claim. They are entitled to receive their money back plus interest. If the business organization does well, the fixed claim does not change. If the business organization does poorly, the fixed claim does not change. In contrast, the equity claim or the residual claim does change depending on how well or poorly the business organization does in its business. So imagine I invest $100,000 into a corporation in exchange for stock. I am now a residual claimant or an equity claimant. I'm an equity owner in the corporation. If the corporation does really well, the value of my equity claim goes up. If the business organization does poorly, then my equity claim or my residual claim goes down. And here's the basic idea. I get what is left over after the business organization meets the fixed claim. So if I invest $100,000 into the business organization and I get an equity claim, let's say I get stock in a corporation, and the corporation does really well and makes profits, well, profits are just the revenue of the business less how much we have to pay to our creditors. And so that profit belongs to me. Similarly, if I invest in a business organization and I get an equity claim, and the business organization continues on for a long time and eventually liquidates, I only get what is left over after the business organization pays the creditors. So think of the residual claim as what is left over after the business organization pays its fixed claimants. This is a concept that we'll continue to explore throughout the course. Finally, a business organization can finance its business through earnings. So if the company makes money, it has profit, instead of distributing that profit to the owners, the business organization keeps the earnings. And this is what we call retained earnings to finance its operations. All right, let's talk about what legal personality is. So a business organization, or at least some of them, are legal persons. They're not natural persons like you and me. They are legal persons. And this simply means that they can buy, sell, and own property, and they can enter into contracts. It also means that a business entity's existence is separate from that of its owners. So imagine I am the sole shareholder of a corporation and I pass away. The corporation still exists. The corporation does not die with me. Its personhood, its existence is separate from my existence. All right, so now let's go through the basic business organizations that we have talked about and discuss whether they have legal personality or whether they have legal personhood. A corporation is a legal person. An LLC is also a legal person. A sole proprietorship is not a legal person. Remember what we said a sole proprietorship is? If you are a single person and you go into business without forming a corporation or an LLC, you are a sole proprietor. You do not have a business organization. There is no business organization that has an existence separate and distinct from you. And a partnership. Is a partnership, does it have legal personhood? Well, you can think of it as having a legal personhood, but the law treats it in kind of this schizophrenic way. Sometimes the law will treat a partnership as if it is a legal person, and sometimes it will treat it as just a bunch of people together running a business. We'll discuss this further throughout the course. All right, let's talk about centralized management. Some business organizations have centralized management, some do not. Centralized management is where the owners of the business do not directly manage the business and affairs of the business. Right? The idea is that you have some sort of management team that the owners of the business appoint or elect. For example, a board of directors. Let's think of a large public corporation. Let's think of Microsoft. I'm a shareholder in Microsoft. Do I run the business of Microsoft? No, I do not. I vote to elect a board of directors, and the board of directors hires employees and appoints executive officers. So we have this large management team that runs the business organization. This is the concept of centralized management. The consequences of centralized management is that you have what we call agency problems and agency costs. So I am the owner of Microsoft. I am a shareholder in Microsoft. I have the equity claim. I have the residual claim. I am one of the many owners of Microsoft. I have a bunch of people, the board of directors, and the management team of Microsoft that are running the business on my behalf. Anytime a principal, and in this case we'll look at me, the owner or one of the owners, the ownership, part of the ownership body of the corporation as the principal, anytime a principal gives discretion to an agent for the agent to run a business on the principal's behalf, we have agency problems. The agent might shirk. And what does it mean to shirk? Well, the agent might either goof off and be lazy and not run the business carefully, or the agents might benefit themselves at my expense. These are agency problems. And agency problems, because we have these agency problems, there are costs involved. How am I to protect myself from these agency problems? How am I to make sure that the agents that I engage to run the business on my behalf do not shirk? Well, I have to engage in certain activities, and these activities have costs. We'll talk about agency costs in a little bit. How does the law deal with agency problems and agency costs? Well, one way is to impose fiduciary duties on the agent. So the board of directors and the management of Microsoft, under the law, have a fiduciary duty to engage in their activities diligently and honestly. And that's how the law, or one of the ways the law deals with agency costs, by imposing fiduciary duties on the agents. And we'll explore fiduciary duties in depth in Chapter 6, and we'll also talk about fiduciary duties throughout the course because they are a core concept to business organization law. Let's talk about the transferability of ownership interest. Remember, we're talking about ownership interest, we're talking about the residual claim, we're talking about equity interest. And sometimes that will be called stock or shares. If it's a corporation, the equity interests are called stock or shares. In an LLC, the equity or ownership interests are called membership interests. In the partnership, your ownership interest in a partnership is called a partnership interest. Now, these equity interests have control rights and economic rights. It's helpful if you break down the rights of the equity owners into control rights and economic rights. Think about what ownership means with respect to anything. If you own a piece of land, you have control rights over that land, and you have economic rights in that land. What are the economic rights of an equity holder or an owner of a business? Well, it's the residual claim. And we discussed that, but once again, let's review what the residual claim is here. The owners of the business are entitled to whatever is remaining, the residual, after the business meets its fixed claims, after the business is able to pay off its creditors. Well, this whole slide was supposed to be about the limits of transferability. So now that we understand what the equity interests are in the various different business organizations, we have to ask, can I freely transfer my equity interest? Now, you might say, of course you can. It's something you own, and U.S. law is very pro-transfer, right? You've taken property law, and you know that restrictions on the transfer of property are looked upon with disfavor by the law. Well, there are some limits on transferability of ownership interest. Now, we're going to talk about this in detail in later chapters, but let's just cut to the chase. Stock or shares in a corporation, the default is that these ownership interests are freely transferable. Membership interests in an LLC, generally, the law is that the default is that these ownership interests are not freely transferable. What about partnership interests in a partnership? Once again, the default is similar to the LLC in that the ownership interests are not freely transferable. Once again, we'll explore this in greater detail in a later chapter. Let's talk about the basic relationships and conflicts we'll see in business organizations. We've already discussed them a little bit. Let's look at them again. You will have conflicts among owners and managers. You will have conflicts between the owners, and you will have conflicts between the owners and the creditors. So there are other ways that we might phrase this, and just to practice the terms that we've been using when we're talking about conflicts between owners and managers, we can also refer to this as conflicts between the residual claimants and the agents of the business organization. When we're talking about disputes between owners or conflicts between owners of a business organization, we can say that we are discussing conflicts between the various residual claimants of a business organization. And finally, when we talk about conflicts between the owners and the creditors of a business organization, we can say that we are talking about conflicts between the residual claimants and the fixed claimants. We've already talked about fiduciary duties. Let's refresh our memories about what fiduciary duties are. It's the situation where we have a management team or agents, and the agents are running the business on behalf of and for the benefit of the equity owners, the residual claimants of the business organizations. What are fiduciary duties? Well, fiduciary duties require the agents of the business organization to perform their duties diligently and honestly. In other words, they have to perform their duties carefully, and they have to perform them honestly with loyalty. In other words, they have to run the business for the benefit of the residual claimants, the owners of the business, and not for themselves. The agents cannot benefit themselves at the expense of the owners of the business. Now, as we study fiduciary duties, we'll see that the law will only hold the agent liable for the most egregious breaches of their fiduciary duties. So keep that in mind. As we're exploring fiduciary duties, remember that fiduciary duty law protects the owners by imposing fiduciary duties on the agents, but it also provides a significant amount of protection for the agents. The agents, under the law, will only be liable for the most egregious breaches of their fiduciary duties.